Mulvey versus Sandburg High School is a case about two parents, Joseph and Ellen Hogan Mulvey, their daughters Kathleen, who was a minor at the time, and Megan, bringing a case against the Sandburg High School, Consolidated School District 230, the superintendent, assistant superintendent, coaches, and other district employees for being indifferent to bullying and breaching the contract that was present to them in the student and athletic handbooks. The reason that they found these cases to be relevant and therefore breaching a contract was because in 2006, Illinois passed a statute that every school district must have anti-bullying instruction for all grade levels, and in 2007, it was required that schools communicate their bullying policy to students and their families on an annual basis, which was done through the student handbooks at this particular high school. So the Mulveys took these contracts and they sued on 3 accounts. They thought that Megan and Kathleen suffered damages from being bullied by their basketball teammates in person and on social media. The defendants breached their contract with them by not addressing the bullying, which caused them to experience emotional pain, distress, PTSD, the need to change schools before their graduation, and a plethora of other damages. Their second count was that if they would have been protected from bullying, then these damages would not have been ensued, and this was a result of the defendants being indifferent. Count 3 was the same as count 1, but it was for the parents suffering damages due to the lack of addressing of the bullying. The defendants filed for a motion to dismiss the amended complaint put forth because the handbooks did not hold the necessary attributes to be considered legal contracts. In order to be a legal contract, it had already been determined that one must have an offer, acceptance, and consideration. Since these 3 specific things did not occur with the student handbook, the defendants felt that count 1 and 3 should be dismissed because these parameters are not present. They also felt that count 2 should be dismissed because a cause for the willful and wanton conduct was not provided, and the plaintiffs did not present that the defendants were even aware of the threat or that there was deliberate indifference. They supported this dismissal with the fact that Megan's claims were time-barred and that a school could not have claims held against them for imposing bullying discipline due to the Illinois Local Governmental and Governmental Employees Tort Immunity Act. The circuit court agreed with count 2 being dismissed, but they did put forth that the plaintiff could amend it and be more specific, but counts 1 and 2 were not dismissed. Counts 1 and 3 were not dismissed. The defendants requested the case be reconsidered, but the circuit denied it and demanded a response to the plaintiff's amended complaint. The school district still held that public school handbooks were not contracts, and if they were to be deemed as such, it would undermine the state's power to operate public schools. The circuit court agreed and dismissed counts 1 and 3 at this point, and the plaintiffs were able to amend their complaint again. Their second amended complaint maintained the same complaints that were in the original, and as such were struck down again by the circuit court, and this time they chose to sue and take their claims to the appellate court. The appellate court upheld the circuit court's decision. Count 2 was dismissed because of the Tort Immunity Act and Megan's claims being time-barred by 1-year statute of limitations. Counts 1 and 3 were dismissed because presenting a student handbook cannot be deemed as a contract.